afternoon and welcome to the webcast on Economic and Commercial Law Executive Program being organized by the ICSI. We have CS Pankaj Kumar as the faculty for the day. CS Pankaj Kumar is fellow member of the Institute of Company Secretary of India and a Chartered Security Investment CSIA London, or he is also a MBA Finance. He is faculty at NIRC for subject like industrial law, economic law, corporate restructuring and due diligence, as well as securities law. We will give a brief overview of the coverage of the syllabus and explain conceptual aspect and conceptual framework and various law covered in the subject. He would also answering students' query during the discussion. Now I handed over to session to CS Pankaj Kumar.
Very good afternoon to all of you. Thank you, sir, for such a nice introduction. Once again, very good afternoon all the students. There are two kind of heat burning. One heat is the chilling, and you can say that this is a weather where the sun is really becoming very a cruel enemy of us. But don't worry. The thing which is worrying you most is that in the heat pressure of your examination. I cannot assure that how can I reduce the heat of sun, but I can assure that you will get some relief and you can get some kind of ice on your second heat, that is the pressure of the examination. So what I will do and how I will cover this one, like we will go through with each and every part of ECL, and this is up to you. You continuously have to make the questions, and meanwhile I will take the questions, and the moment till your question is coming, I will introduce you one by one all the chapters and all the aspects, and we will discuss number of things, and these all things will be related to your examination. Today we will focus on only on our examination point of view. That means how we can perform well and how we can get well in the examination. Before we start, I will try to make you a short summary of how you can prepare and how you will encounter your question paper. Just have a look here. This is a subject which is known as ECL. Fine. You will get two parts over it. This is part A and this is part B. Here 70 marks and here you will get 30 marks. Although there is one generality in this pattern, but that is not given by the institute. The institute has given us that they will ask 70 marks question from part A and 30 marks question from part B. I will give you introduction of all those aspects. That means what exactly in this part A and what exactly in this part B, and we will cover each and every topic. The topic which is most important, we will cover that first and then we will go further. Meanwhile, you are free to ask the question. If you are asking a question, I will stop, I will answer that question, and I will also take some question after the end of the session. So first of all, I will give you a brief about this part A. That means what exactly is the course content in part A. Just have a look of course content in part A. What you are finding over there? You are finding that there are FEMA, FCRA, and why there is two things has been written, FCRA 1976 as well as FCRA 2010, because FCRA has been changed, and for your examination, what you will find that it is 2010. Here foreign trade policy, what I have written over there, this is 2009-2014. Why I have written that one? Because you can get your emphasis that now it has been changed, and now what you have to encounter with? You have to encounter with foreign trade policy 2015 and 2020. I will give you a brief that how these foreign trade policies are being made and how this is important that you have to make your emphasis over there. To making your emphasis, I have written especially that is 2009 and 14, because it might be possible that some of our students is having old study material, might be possible, but don't worry. If you having that one, go to our website, you will find each and everything amended over there, and you have to prepare according to that one. MRTP Act 1969. You may think that's it, this all has been resolved and there is no need to go through the MRTP Act 1969. But my dear friend, be very careful. You have to go through with Consumer Protection Act and Competition Act, but there are number of definitions which we are picking from MRTP Act 1969. So you don't have to go through with MRTP 1969 completely, but what exactly? You have to take only the definition part. I will give you the brief. Right now I am just giving you a reflection that what exactly is the content under section, under part A. Then Competition Act, Consumer Protection Act, and in IPR, intellectual property right, you have to go through with 5 things: patent, copyright, trademark, geographical indication, design act. And under this you also have to go through with World Trade Organization, WIPO, those all aspects. Then Arbitration and Conciliation Act, 1996, Transfer of Property Act, Indian Stamp Act, Indian Contract Act, and Prevention of Money Laundering Act. This is containing your 70 marks and 4 questions. That means this 70 marks will contain 4 questions. Now we have to move to part B. Just have a look on part B. In part B, you will get Essential Commodities Act. This is Standard Weight and Measurement Act 1976, which is popularly known as Legal Metrology Act 2009. Sometimes you will get it as 2010, but don't get affected with that one. Society Registration Act, Indian Trust Act, IDRA 1951, MSME Act, Registration Act, and then under Pollution Control and Environment Protection, you have to go through with 5 topics and 5 acts. One is Water Prevention and Control of Pollution Act 1974, then Air Prevention and Control of Pollution Act 1981, Environmental Protection Act 1986, Public Liability Insurance Act 1991, and National Green Tribunal Act 2010. Now, what we have to do? We will start from very first thing and we will go through with all these aspects. So now again come to the board and just take a close encounter of all those aspects. So now tell me which part you are finding most important to you. I tell you very honestly, never make any kind of bet for your examination, because some of the students are thinking that if the question is coming from Registration Act, if the question is from Society Registration Act, if the question is coming from Trust Act, we will make our emphasis over there and we will eliminate FEMA, we will eliminate some other IDRA and those other conceptual chapter. My dear friend, don't do that. Institute is expecting each and everything from you. So what you have to do? You have to cover your complete syllabus. And I will help you out that in which area you have to focus most, because if we will go through the question, then what we are finding? We are finding that we have to answer short questions, that means short notes. We are finding that there is some question which is saying that distinguish between this and this. There are some question which is asking that comment on this topic. There are some questions related to case law. So whenever you are reading any chapter, you have to extract and you have to make your concentration on all those 4 aspects. That means if you are reading one chapter, so what you have to do? You have to find out that what kind of short notes will come from this chapter. Find? Might be if you are reading IDRA. Fine. So you have to, first of all, what exactly you have to extract? You have to extract some short notes like industrial undertaking. Then you will find substantial expansion and number of things we will discuss. Then you have to make distinction. That means there may be question and they may ask you that distinguish between this and this. So you have to make all the aspect that what kind of things can be asked under this section. Then comment. Under this, what you will find? Under this, you have to make your concentration on the part that there is a sentence written over there like Special Economic Zone is search engine of our economy. This is one sentence. And now, what can be asked? They may ask you that comment on this. For that, you have to be very much prepared. This is the comment. Then what? Then case law. Case laws, in which you will find number of things from various chapters like Consumer Protection Act, intellectual property right. These two important chapters are with the point of view of case law, because case law can be asked from any area. It might be from IDRA, it might be from SME Act, but most importantly, it can be asked from Consumer Protection Act and intellectual property right. So these four segments in which you have to make your concentration: short notes, distinguishing, then comment, and then case law. And on the basis of this, you have to cover all of your chapter. Again, a very humble request: don't left any chapter, and don't think this is important, this is less important. If you will get a question from that, that will become important. So cover your entire syllabus, and we will try to cover the each and everything, but definitely in a brief. And if you have a question, continuously keep passing me the question and I will answer that one. Before I am getting any question, I will start from IDRA. Fine? So we will start our discussion from first topic, and that is IDRA. Industries Development and Regulation Act, and in parallel MSME Act. This is Micro, Small, Medium Enterprises Development Act. Now, what is this? In IDRA, we have to make our concentration that there are a number of things which is related to short notes, like what is industry, what industrial undertaking, what is substantial expansion. So what is industry? You are finding there are a number of product over there, like I am wearing this clothes, you are wearing your t-shirt, and number of people sitting their home and getting number of different kind of clothes on their body. So these are the clothes. But can you tell me that if we have to make a group, then how can we group it? We can group it like a textile industry. Suppose we are using different kind of medicine like Calpol, like crochet, like decold, and like different belladonna, different kind of medicine. But do you know that when we have to make a group, how can we tell it? We can say that this is from drugs and pharmaceuticals. So whatever product we are finding, whatever product we are using, IDRA has comprises those all into a single category, and that is known as industry. And we have now 38 industries. That means all the product are under 38 industries. That means if clothes, then this is one industry, that is textile. If there is medicine, that is one industry, that is what? Drugs and pharmaceutical. Don't think this is a drugs of this kind of drugs. No, these drugs means drugs and pharmaceuticals. Don't think it's a literal meaning. Now, drugs and pharmaceuticals. Then IT, information technology. Now, what government was thinking at the time of 1951 when IDRA was commenced? Government has to increase and improve the industries. Like what we are finding that in 2002, the industry, that means IT industry, was not very much developed. But due to the continuous effort of government, handloom and handicraft, what we are finding earlier, that means the people who were doing the work of handloom and handicraft were not getting the meal for the 2 times. But nowadays, if you try to buy some kind of handloom or handmade things, you have to pay thousands of rupees, sometimes lakhs of rupees. Why? Because government has made their emphasis, and government has made different kind of approach for their marketing, for their exhibition, and then this product become need, and this product become the hot selling product, and these all products are being exported outside India, and we are not getting those products. So there is some regulatory body who are continuously making their effort to make industry improve. That means continuously they are trying to find out that which industry is not very much improved, and then they are trying to make the improvement and doing number of things. For that, they evolve 2 kind of regulatory body. One is CAC, Central Advisory Council, and another one is Development Council. Now, the IDRA has 3 objects. Just look at here. These 3 objects are development, development, then regulation, and then control. These are three objectives and three purposes of introducing IDRA. Under development, there are two authorities, regulatory body. One is Central Advisory Council and another one is Development Council. As I mentioned you, right now we have 38 industries. That means if we will introduce some product which is not coming under this 38 industry, then we will make another industry, industry. But if suppose now more than 1 lakh medicine are available, but suddenly you are introducing another one medicine, there is no need to introduce another industry. Why? Because we already have drugs and pharmaceuticals. We insert that medicine under this industries. But if we will introduce some kind of things which is not under this 38 industry, then we will introduce 39th industry. Earlier, 1951, we were with only 22 industries. That means now 38 industry, but earlier there was only 22 industry. That means this 16 more industries has been introduced, because by the growing of time, by passing of time, each and every day we are inventing some kind of different thing. And when we are introducing some different thing which is not suitable under one industry, we are making another next industry. So for development of this industry, we have two. One is Development Council, another is Central Advisory Council. This Development Council is for each and every industry. That means right now we have 38 industry. So we have 38 Development Council, and this Development Council has the responsibility only on to do what? To improve that industry only. That means if that Development Council is for textile, he is not going to interfere in any activity of drugs and pharmaceuticals. He is not going to interfere any activity of your information technology or any other industry. So this is working like a chief minister. Like in a state, there is chief minister, and this is Central Advisory Council. This is like our prime minister. That means prime minister has the control over all the states in the similar fashion. This Central Advisory Council has the control over all these 38 industry. This Development Council is for each and every industry, and this is for all 38, and this is for separate. That means for each industry you have one Development Council. And now what they will do? They will make advertisement, they will make publicity, they will invite the foreigners, they will invite the foreign investment, and they will do all each and every aspect which can increase the marketability of that product. I'm giving you one example. I just remember one incident. When I was child, I was finding that there was limited people who were having telephone connection at their home. That means there was that phone of tring kind of phone, or there was the typing phone. There was no mobile, nothing else. So whenever any house is having one telephone connection, the child of that house is getting very much privileged, because that was the child who will shout, "Chadda auntie, this is your call and you have to come and attend the call." So whenever that fellow is going to Chadda auntie, then Chadda auntie is giving some kind of toffee chocolate. Then only we will shout Chadda auntie. Otherwise, if there is call of Chadda auntie, I'm not going to shout, because I have to do my homework. So earlier there was only that kind of phone. Then what happened? Then the cordless came. Then each and every, earlier when there was a call, then each and every people was coming to the telephone, that okay, this is my turn, now I have to talk. This cannot move. Each and every person has to come there and they have to attend the call. Then the cordless, now the mobile. And when there was a time of that kind of phone, each and every people has to make very hard effort for getting that connection. That means for BSNL and MTNL, you have to make your approach. Now they are approaching to you, and what they are providing you, if you are making any call between 9 to 6, that is chargeless. And this is the fact, because I have one connection at my house, and after 9 o'clock we are start chatting with each and every relatives. So they are not charging anything. Why? Because there is competition now on mobile. Earlier when mobiles came, you have to pay for the outgoing. Now if you are getting a call on your mobile, there was one Virgin Mobile earlier there, who is getting you and giving you some kind of balance if you are talking through that connection. So that means how these all things has been changed. This is the effort of this Development Council and this Central Advisory Council. Handloom and handicraft. when the poor people was making some kind of things from their for some kind of bamboo flakes. If you have some kind of experience at rural area, you will find that people were making different kind of structure and a structural object from that bamboo flakes, and that things were very cheap. But nowadays, due to the blessing and due to the effort of Development Council and Central Advisory Council, those things are costly paid and they are getting very good revenue. Now, the second thing is regulation. But regulation is what? Regulation is like they are appreciating you, that means Development Council and Central Advisory Council for you and for your development. But there are some rules and you have to abide by the rules and regulation. We have 38 industry, but these 38 industry is divided in two sections. One is licensed sector and one is de-licensed sector. And we have 8 industry in licensed sector and 30 in de-licensed sector. This means what? If you are making any kind of product, which product is under this category, for doing and for making that product, what you have to do? You have to take the license. But if you are making any kind of product and which is under these criteria, this category, then you don't need to go for the license. For that, you just need to take only IEM. This is Industrial Entrepreneur Memorandum. And if you are under this category, then you have to take FCIL, popularly known as Industrial License, but the complete name is Foreign Collaborator and Industrial License, and we may call it as license. So suppose I'm making and I've started making this marker. This marker is under this section because this there are some kind of chemical under the, as a fluid in this marker. So I have to take the FCIL. But if I'm making some kind of product which is under these 30, that means I have to take only IEM. This IEM is also one kind of permission, but for this permission there is less formalities. FCL is also one kind of permission, but for that you have to go through the rigorous procedure, like you have to go to the SIA, then you have to go to DIPP, then DID, then you have to go to the concerned ministry, then it went to the another person. That means there is number of chain over there. So now whenever you are doing this, you have to take FCIL. Whenever you are doing IEM, then you are under this category. But undertaking, I am writing some definition and you just have to make a very good effort on that one. And if you have any doubt, then do revert back to me, then only I will discuss, because we have limited time. So I am mentioning some kind of definition which you have to go through, and if you have any kind of doubt, just revert back to me. This is industrial undertaking, this is scheduled industry, then industrial undertaking, existing industrial undertaking, then substantial expansion, then effective steps, then SSI already discussed, ancillary industrial undertaking. You have to go through with these all aspects, and then FCIL, IEM, this all. So there were 3 objects. One was development, another was regulation. Then under regulation section, what the government has told us that if we are doing this, then we have to take FCL, otherwise we have to take 30. This we have to take IEM. Now for the control, suppose industrial undertaking is not performing well. Not performing well means what? When you are taking FCIL, they are providing you some aspect. What are those aspects? They are giving you that you can produce these products. That means name of product, then quantity, then quality. You have to come up with these expectations. This name of product means what? If government is providing you to produce this, then you cannot produce anything other than this. Otherwise, you have to go through with the license one. Now, suppose you are not producing that thing, or you are producing the thing, but you are not producing as per the specification. That means deteriorated the quality, Or the government has given you to produce 1000 marker. Why they have given you the license for 1000 marker? Because there is need of 1000 marker. But you have stopped producing, you had stopped producing 1000 marker and you just maintain your production at 500 pieces. Now tell me, how can the market get those 500 products? How they can get their need? In that case, government can make a takeover decision on that industrial undertaking. That is known as control. Government is giving you development. Government is giving you rules, regulation. If you are fulfilling rules, regulation, then there is nothing to worry about. You just go through with those guidelines and produce continuously. But the moment you will make any kind of breach over regulation, then there will be control mechanism. And this control mechanism is of three kinds. And you have to make a very good concentration over here, because number of times we can expect the student to aware with this part. Like this is takeover of industrial undertaking. Don't get confusion of this takeover and the substantial acquisition of shares and takeover regulation. That is a different thing. That is related to a company, but this is related to an industrial undertaking. Now, 3 segment. First, takeover of industrial undertaking with, that means after investigation or with investigation. After investigation, then without investigation, and then takeover of closed industrial undertaking. Now, after investigation means what? That means government will provide you reasonable opportunity of being heard. And what will happen if the quantity has been reduced, quality has been reduced, or you are trying to waste the scarce material? In that case, government can make a takeover, but for that they will give you some kind of reasonable opportunity, that why you are reducing the quantity, why you are deteriorating the quality, and if you are maintaining that ones, then there will be no takeover. But if you are not satisfying that one, then there will be a takeover. This is under section 18A, this is 18AA, and this is 18FA. The thing which is not very serious, that comes under 18A, but the thing which are very serious in nature, that comes under 18AA. Why 18AA? In 18AA, government is not going to make any kind of investigation. What will they do? They will directly make a takeover over your industrial undertaking, because the situation is very crucial. I am giving you one simple example. Suppose somebody in your classroom, you may remember and you might remember at your school time, when the people was started writing drawing and started writing something on your back. That means there was, if the white color shirt, they are making some kind of marker, and we are arranging this marker only to make some kind of hurdle work. That means writing on the back of the student. Suppose now the class teacher is coming. If you are shouting that ma'am or sir, somebody has written on my back, what the teacher will do? Teacher will make an investigation that whether there is any marker in his or her bag, and if the ma'am or sir is getting that marker, then only he or she can take action and just let that people to go to the outside or any kind of punishment. But suppose ma'am is coming or sir is coming, and you are just making your hand at your head, and there is one another student having one hammer at his hand, and you are shouting that, sir, that fellow has struck me. What the teacher will do? Whether the teacher will inquire that this hammer belongs from iron, or this is of a stainless steel, or this is of a stone, what exactly, how much Newton's force has been introduced to hammer on that fellow's head. So there is no such time, because that time he or she will make such kind of investigation, that fellow will instruct one again, and now the head will in front of that teacher. So what she or he will do? Just directly he will tell that, okay, put that fellow and keep it outside the room. This is the similar situation. The situation is very crucial, and there is no time, there is not at all any time for the investigation. This is without investigation. Now, takeover of closed industrial undertaking. This is another situation. What exactly is this situation? This is a situation under which government is finding that there is an order from the High Court that closed this industrial undertaking. But government is just trying to make some kind of a scope so that the employment can be saved. Unemployment is very big issue in India. And what will happen if there is employment and that employment is going to be reduced? So this is the situation. If we have employment, we just have to manage that one. And if any industrial undertaking is closed, we just have to make investigation that whether that industrial undertaking can be started, whether there is need of that product, and if it is possible, that industrial undertaking can be taken over by the government and that can be started. In each and every case, this takeover can be made maximum for 5 years at one go. And if government is still finding that no, still we need some more effort to make that industrial undertaking more smooth maintenance or running, then they can go for another 2 years extension, then again 2 years extension, then again 2 years, 2 years, 2 years and 2 years. That means 6-time extension of maximum 2 years. So this is about the industrial undertaking and all about the IDRA. Now, the another part which is relating to this is MSME Act, micro, small and medium enterprises. So if you have any query, you can send me any query related to this IDRA. We will discuss that one. And I'm moving ahead for MSME. So if you have any query, we can take that query.
Existing industrial.
Okay. What difference between economic explained famous? First, I would like to take the question of existing industrial undertaking. Fine. What is an existing industrial undertaking? Okay. IDRA 1951. What does this mean? 1951. This is the year when this act was commenced. The year 1951, there were number of industrial undertaking which were already existing. This is known as existing industrial undertaking, 1951. And any other industrial undertaking for which effective steps has been taken, that is also comes under industrial undertaking. Suppose you are finding there is one building that is a finished one, and you are finding some kind of land that is completely empty, but there is something which is not completely empty and which is not completely constructed. That means a house under construction. So this is very clear that the industrial undertaking which was already in existence at the time of commencement of this act, that means at 1951, is known as existing industrial undertaking. But if there is any industrial undertaking for which effective steps has been taken, also been included under existing industrial undertaking. Now the question is that what exactly is the meaning of these effective steps? How can we define the effective steps? There are 3 conditions. If you are fulfilling any of 3 conditions, that is comes under effective steps, and that industrial undertaking shall also be known as existing industrial undertaking. What are those steps? First, 60% of the capital has been used. That means if there is 1 crore rupees were required, that means 1 crore was your paid up capital, and you already utilized how much? 60%, that means 60 lakh rupees in, that means working of that industrial undertaking. This is known as effective steps. Although 100% has not been consumed, 100% industrial undertaking has not been established, but 60% of your paid up capital has been utilized. The next one, substantial part of plant and machinery has been ordered, not purchased. That means if you are looking for 1 crore plant machinery, substantial means more than 60%. That means you have made the order for more than 60%. That means you made the order, not already the order has been made. You made the order, you have given the payment. So this is called substantial plant machinery order has been given. Now the third one, substantial part of land and building has been completed. That means the construction work has not been completed, but substantial part has been made. There is no need to comply all three simultaneously. If you are complying with any of these three, this is known as effective steps. And if any industrial undertaking has taken effective steps at the time of 1951, this is comes under existing industrial undertaking. Is it very clear? Fine. Another one is, what is cartel? I will take this question. Explain the rule of prevention of money laundering. Not an issue. Since this is the question, I will take this question, then we'll move forward. Fine. When I am answering you and you are still having any kind of doubt, kindly mention that one, because I can explain that one in more simple word if still you have any kind of doubt. So don't just keep yourself set that, okay, my thing has been done and I have got the answer. If you are very much satisfied, very good, very good. If still you have any kind of doubt, revert back to me. Now, what is rule of prevention of money laundering? There are three stages. This is rule of prevention of money laundering. There are three stages of money laundering. The one is placement, second one is layering, and third one is integration. Integration. What exactly is happening in case of money laundering? We are finding that people having the black money, but if they will make the investment of complete money at one place, definitely they can be recognized or they can be noticed. So what they are doing? If they have 100 crores, they are making investment in segment wise. Segment mentions what? In a small pieces. They are making investment of 1 lakh, 2 lakh, 3 lakh, different businesses. And what they are doing? If they are making investment in one business, they are just trying to transfer that money to another business. So investment of your huge amount in different, that means small pieces is known as placement. Then what they are doing? If I'm making investment in, suppose, a simple business, a garage, then whatever I'm getting from that garage business, I'm trying to make the investment from that one to the another one, like opening a small hotels. Then from that hotels, I'm transferring it to a different, like opening a toy shop. In this manner, I'm making chain by chain, making rotation of that money so that nobody can catch me. And if he is trying to find out that what exactly is the source of that money, he can get confused. Suppose I'm giving some money to that fellow, then that fellow is giving to another person, then that one is to another person. And if the regulatory body will try that this money belongs from which person exactly, they will get confused and they can never come back to me. This is known as layering. Then what next? Integration. Now, the money has been just moved forward, and what I will do, when the regulatory body is not able to get what exactly is the source of that money, then I will try to integrate those all money. Now, I made investment 1 lakh rupees in garage, I will try to collect that one. I made 1 lakh rupees in small dhaba business, I will get that one. And this is known as integration. Now, if we have to make the rule for prevention of money laundering, we have to hit at all these three stages. And the rule has been made on two shapes, one nationally and another one is globally. National level, we made prevention rule has been made with two levels. One is national level and another one is global, because money laundering is not the issue of our country only. Because if India, any person is getting money in black from India, since we can make investment outside India, so what exactly is happening? USA market is getting some kind of money which is a black money. If some person is making any kind of wrongful activity or business outside India, that means in USA, and if he is trying to make investment in India, that our market is also going to be affected. So we had to make two-level prevention and protection. National level, we started KYC guideline, and KYC guideline was made by RBI, and under this KYC guideline, RBI has given the instruction to bank and financial institution that they cannot become a part of money laundering. Whenever they are opening any account, they have to make a very good check that what is the authenticity of that person. Whenever any person is making any kind of transaction, you have to just be sure that he is getting from which place, because whenever we are going to open the account at bank, what we are finding, we have to mention that what is the source of income, what exactly we are, what exactly is our profession. And if bank is finding anything beyond that one, they had, and this is their responsibility to inform the RBI. So this is at national level. And RBI has given the circular that each and every bank will keep record of each and every client. Even after the closure of account, they have to maintain the account for more than 8 or 10 years. At global level, we establish Financial Action Task Force. Global level, this is Financial Action Task Force. This is similar to Rapid Action Task Force. We are calling Rapid Action when their situation is out of control. In the similar manner, we are calling Financial Action Task Force in case of money laundering. This step has been taken very earlier at 84 itself, when all the country, that means number of countries, has taken unanimous decision that whenever any money laundering activity is going on, we shall make intimate to the another country. Suppose if any kind of money laundering is going on at India, India will intimate USA that be very careful, this is one fellow doing money laundering over here, be careful, he shall not make investment in your country. So this is Financial Action Task Force. He will inquire that the rule, regulation and act, that means the Prevention of Money Laundering Act 2002 is initiative of Financial Action Task Force. In the similar fashion, Financial Action Task Force is educating the countries about the money laundering, drawback of money laundering, how this is making any harm to our country. So this is the preventive steps. Is it very clear? Shall we move? So next question is, what is cartel? This is from Consumer Protection Act. Not an issue. When I will discuss Consumer Protection Act, I will give you the brief, but I will discuss this cartel right now. Cartel. In simple word, cartel means what? Cartel means a combination. Cartel means a combination. Consumer Protection Act, we were saying that we have to prevent the consumer, but the concept of cartel came after the enhancement of Consumer Protection Act, and this is Competition Act 2002. Earlier we have MRTP Act, then Consumer Protection Act, and now this Competition Act is replacement of MRTP Act 1969. Under this cartel, if any association has been made, that means any person is trying to make any kind of restriction or limitation on production, supply or distribution of product, this is known as cartel. But there is some cartel which is restricted by the Competition Act, not each and every. Suppose this is Reynolds. I'm not advertising since in my hand, that's why I'm saying the name. Suppose a company's name Reynolds, which is making marker, and another company which is known as Camlin, also producing marker. Another company, Lexer, producing marker. Now these three companies are doing what? These three companies are selling their product at 20 rupees each. Why? Because there is very tough competition for Reynolds, for what I said, there was one Lexer and one was Camlin. Fine? Three companies. Now, if the Reynolds will increase the price of the marker, all the customer of Reynolds will go to either with Camlin or with Lexer. If Camlin is doing the same, then their customer and their client will distributed between Reynolds and Lexer. So what they are doing? They are trying to make some kind of association that, okay, fine, you have your own client at 20 rupees, Camlin has their own client and Lexer has their own client. They made their hand together and decided to sell the things at 25 rupees. Now what will happen? If I will go to the shop and I will demand for the marker of Reynolds, they are saying me that this is of 25 rupees. What I will say to that fellow, stop doing that, give me the marker of Camlin. Okay, he will give it to me, and again I will ask how much I have to pay. He is saying that 25 rupees. I get afraid. Again, stop that one, give me the marker of Lexer. Again, they are quoting me 25 rupees. Then what I have to do? I was a user of Reynolds, and now I am trying to switch over. But what I am finding, they are also providing at 25 rupees. I don't have any way. I will pay the 25 rupees and get the marker of Reynolds itself. This is the cartel. That means you are making a combination, and through that combination you are trying to restrict, you are trying to limit, you are trying to control the market. Some kind of cartel has been prohibited, and those cartel is known as anti-competitive agreement. Since this is not the question you have asked me about the anti-competitive agreement, I will discuss those all things by myself when I reach at Competition Act. So this is the cartel. So cartel means what? This is the combination, association of a group of people, of person, and through that they are trying to limit, they are trying to restrict, and they are trying to control the market. Is it very clear? So fine, cartel done. Then what is the difference between economic and commercial law? Okay, economic and commercial law. Literally no difference at all. Economic and commercial. Whenever saying that economics, this hit to a complete India. That means this is a bigger segment. Whenever we are saying about commercial, this means what? This means that if we are doing something which is fulfilling the need of a person, then there will be no rule, there will be no regulation, there will be no act which will be enforced on you people. But when we are saying economic, it means the thing which can affect the country at large. When we say the commercial, this means we are doing some kind of business activity. So if you are asking this question to very technical point of view, this means the commercial activity which is meant for getting some kind of profit, and economic means this profit is somehow contributing to the growth of country. That means by the manner of GDP, NDP, and this manner. So this is economic and this is commercial law. So the law through which we can control the country's overall improvement and growth comes under economic law, and commercial law, which is directly related to when a person is trying to make any kind of business. Now, FEMA in short, don't worry, I will explain FEMA in short, and not in short, but I will give you a very good summary of FEMA because there is number of amendment in FEMA. So I will make your focus on that one. Applicability of foreign trade policy for June 2000 exam is FTP bill. Exactly. As I mentioned you earlier, there was FTP 2009 and 14. Now FTP 2015. Don't get any kind of confusion at all. This is applicable to you. And what is this FTP? This is 5-year plan. Whenever any government changes, then what they are doing? They are making their 5 years plan. That means how they will develop India. In the similar fashion, this foreign trade policy is a 5-year plan for our export and import policy. So now you have to emphasize over there. That means this is applicable. This is your question. I have answered this one. But what exactly is this in this FTP? I will discuss it. Now, each and every question has been taken from this slide. Again. Okay, there is number of questions people are asking. Salient feature of FEMA. Don't worry, I will start it first. And another one question is from IDRA, so I am taking that one first. What is substantial expansion? Substantial expansion means what? Just look at here. Substantial expansion means, I mentioned you earlier that we have 38 industry. Do you remember that one? And I divided it in two parts. One was 30 and then this 8. This 8 was under licensed sector and this was under de-licensed sector. If you are under this licensed sector, then you are getting FCIL, and if you are under this, you are getting IEM. Whatsoever you are getting, there are 3 aspects which the government will mention. What? Quantity, product, and quality. That means what are the products, what are the things which you will produce, how many number of that thing you produce, and what exactly is the quality. Suppose you get a license under FCIL or IEM that you will produce 100 pieces, suppose, of this marker itself, 100 marker. Now, you started producing more than 100. If you are started producing more than 100, then if you are producing up to 25, that means up to 25% more, then there is a different criteria. But if you are producing more than 25, that means 126 or 127 or any number. So any increase beyond 25% of your license capacity is known as substantial expansion. I am repeating the same. Any increase beyond 25% of license capacity, I am saying beyond 25%. Mind it, up to 25% not, more than 25%. The moment you started producing 126 quantity, then this is substantial expansion. 27, substantial expansion. But what happens if you are within 25% but more than 100%? In that case, three things shall be checked, and that three things is, suppose you started producing 120 quantity, possible? If this would be 126, then it was substantial expansion. Since this is within 25%, then you have to check three aspects. If you are satisfying these three aspects, then although you are increasing the quantity, but this will not be substantial expansion. But if you are not fulfilling all these three quantity, if you are lacking at any point, this shall be considered as substantial expansion. The first thing, you are not hiring any extra plant machinery. No extra plant and machinery. What does this mean? That means earlier you were producing 100 markers. By same plant machinery, you started producing 120 markers because you increased the capacity. Then the first condition has been fulfilled. Another one, second thing, no forex has been involved for the increasing part. Suppose you started preparing 120, that means 20 extra product. If you are investing any forex, that means any currency other than Indian currency is known as foreign currency, and in short, foreign currency is known as forex. So if you are using any dollar, using any pound, any yen, any rubles, any sterling, this is known as forex. You are not utilizing any foreign currency for that increased 20 quantity. That means you are fulfilling the condition. Third one, no scarce material. Scarce means what? The things which is rarely found in our earth, that means very crucial and having very limited quantity. Suppose earlier you were producing 100 marker with 10 gram of this scarce material. Possible? 10 gram of this scarce material, you were able to produce how many pieces? 100 pieces. Still you are using this 10 gram, but you increase the technology. You increase the technology, and by the use of this 10 gram scarce material, now you are producing how much? 120 quantity. That means you satisfied all these three, and there will be no substantial expansion. So if you have increased your production by more than 25%, this is substantial expansion. And if you are not able to comply or fulfill any of these three, then this is known as substantial expansion. So if there is increase in more than 25%, you have to say substantial expansion. But if up to 25%, you have to check 3 points, point 1, point 2, and point 3. And if any of these points has not been fulfilled, you can say that this is substantial expansion. Fine. So this is discussed. Now, procedure of arbitration, then the characteristics of foreign trade policy, what is the difference between Competition Commission and Competition Appellate Tribunal, what is the essential commodity. Fine. So start with the last one. What is essential commodities? Under Essential Commodities Act, government find the need that there are some product which shall be equitably distributed. Just try to comprehend this word. I am saying equitable, I am not saying equal. Government is trying to make the equitable distribution of commodity at fair price, and which those all commodity which comes under essential commodities. And what is those essential commodities? Drugs, pharmaceuticals, food grains, those all things which is our necessity, those all things are comes under essential commodities. And government has a power to make the notification, that is known as NIOG, notification in official gazette, can make any another product under this essential commodity. So to make the equitable distribution as fair price, each and every day you are finding that the price of tomato has been increased, and there is black marketing of tomato, there is black marketing of cereals, there is black marketing of onions. Now if any kind of this activity is going on, government cannot tolerate this one, and that's why government has made some rules, regulation, that these things cannot be accumulated by the person in more than that quantity. So in under essential commodities, the person who is requiring it more, suppose I am a family of 3 people and I need only 2 kg rice for a month. I am not getting exactly, but 2 or 3 kg rice for a month. Fine. If this is 2 or 3 kg of rice for a month, then, and suppose there is another house where 10 people over there, then what government will do? Should government will provide just 3 kg of rice to that family? Not. This is not. The government need to provide to those family at least 6 or 7 kg of rice. This is called equitable distribution. The person who has in requirement of that much of thing shall be given to that quantity, but at reasonable price. It shall not be various. Suppose the onion is in black marketing. What you are finding? That you are not getting the onions. You are getting the onion, but for that you have to pay very heavy cost. So under essential commodities, equitable, and that one is, another one is fair price, and that fair price and equitability can be checked by the government, and government will decide what kind of things is under essential commodity. Now the government has given the list, which has already been given in your study mat, the list of all things, and I can say in nutshell, all the drugs, pharmaceuticals, all the eatable things, petroleum and petroleum products, cotton and yarn cotton, those all things, that means fertilizer for our farmers, seeds of vegetables, seeds of fruits, these all are under essential commodities. Okay, so this has been done. Now what is difference between Competition Commission and Competition Appellate Tribunal? Under Consumer Protection Act and under Competition Act, what we are doing? We are just trying to protect the consumer. There are 2 ways through which we are protecting the consumer. First, government is trying to restrict those person who is trying to make some kind of defective product, and that means not efficient services. Another one, if someone is getting that product, they should be compensated. Under Competition Act 2002, they made and they started a provision with 2 kind of thing. One is Competition Commission of India, and another one is Appellate Tribunal. Competition Commission of India will take care of all those activities. If you are a consumer, then also, and if you are a commercial consumer, then also. Because in Consumer Protection Act, the person can get relief if he is a consumer, and the person who is doing it for the commercial activity or for resale shall not take shelter under Competition Act. But under Competition Act, if you are purchasing 5 trucks for transportation, you are also consumer, but under Consumer Protection Act you are not consumer, but in Competition Act you are consumer. So Competition Commission of India is the first authority who will deal these all things, and if you have any doubt, if you have any grievance, then if you are not very much agreed with the decision of Competition Act, then you may go to the Appellate Tribunal in the similar fashion, like there was District Forum, there was a State Commission, and there was National Commission. In the same fashion, first we have Competition Commission of India, and if you are not satisfied, then you can go to the Appellate Tribunal. So now what next? Characteristics of foreign trade policy. Now, what is foreign trade policy? I mentioned you that foreign trade policy is a policy for 2015-2020. 14. Each and every time I'm writing it and crossing it so that you get a clear picture that this is applicable. Foreign trade policy has been made by the government to make export more aggressive. That means we are in need for the forex. But how we can get the forex? How can we get the forex? Should I go for the robbery in foreign banks? No. We have to make some kind of export. If we will make the export to USA, we will get dollar. If we'll export it to UK, we will get the pound. If we'll export it to the Russia, we will get the rubles. If we will export it to the Japan, we will get the yen. So foreign trade policy is a policy which is being made by the government to get the forex. But under this, you have to facilitate your exporter. Suppose I am making marker. Why I will make the export of marker? There must be some kind of benefit, and that benefit must be related to my monetary benefit. If I am getting some kind of monetary benefit, I will get motivated. My dear friends, what exactly? The number one motivation factor is the money. If I am getting money from any business, I get motivated. In my schedule, I am working from 7:30 to 1 o'clock night. But if you will see me at 1 o'clock, you will get me with the same energy. Why? Obviously, because I am getting money at that moment. Suppose someone will ask me that just start delivering the lecture at 1 o'clock. And if he will say me lakhs and he will give me the crore, you will find the enthusiasm under me. And if he will say that this is for charity, no word will come out of my mouth. So the motivation factor is money. Government is picking the same kind of psychology, and government is providing different kind of monetary benefit the person who is going to make the export, and for that they are providing number of benefits. Like if you are purchasing raw material, for what? If you are purchasing raw material for making the product which you will export, then they give you different kind of exemption. They are not charging you any kind of taxes over that one. If you are going for the export, they are not charging you any import or export duty. If you are purchasing any kind of machines, and that machines has been brought from USA. Obviously, if you want to compete in the market, that means international market, you need an equipment which is internationally matched. So if you are importing some kind of things, that means capital goods, then there are different kind of slabs over there, 0%. That means there is no need to pay any kind of duty over there. And you easily know that how much duty right now when we are trying to get any kind of capital goods in India. Government will provide you different kind of facility related to your infrastructure. So these are the things which is the component of foreign trade policy. That means under foreign trade policy, we will try to get the psychology of our exporter, that what exactly they will require. We make them available with all their raw materials. Suppose the raw material not available in India, our government will make some kind of arrangement from other country, and they will provide us the raw material, plastics or chemicals, so that I can make the marker and I can export it. So this is your basics of FTP, foreign trade policy. That means characteristics of foreign trade policy. The only thing, we have to get the forex, so that whenever we are in need of import, we have dollar, we have pound, and we can get imported thing from the USA, we get imported thing from UK. Now, procedure of arbitration. What exactly is arbitration? Nowadays in India, you can easily, if you remember the word of Mr. Thakur, Chief Justice of India, he said that we are lacking with 70,000 judges. That means there are number of cases, but our judicial system is not capable of meet those all cases. Why? Because the cases are increasing and the judges are limited. So at this moment, we are in need of different kind of redressal system. This is known as ADR. This is not American Depository Receipt. This is alternate dispute redressal. So ADR, alternate dispute redressal. What is this alternate dispute redressal? Whenever you see the word alternate, means what? Anything which is not traditional is known as alternate. Suppose there is a dispute between two people. How this dispute is going to be handled? This dispute can be handled by the another means. Suppose you have taken money. Just eliminate that example. Suppose you have a contract with me that you will provide me 10 kg of plastic so that I can make this marker. Fine. 10 kg of good quality of plastic. And if there is any dispute between you and me, how we can take the shelter? We have to go to the court. We have to the court, and what the court will say? Just stay here, I will give you the order. No, there will be tariq. Again, tariq pe tariq or ek aur tariq. You know this word because this is a famous dialogue of Sunny Deol in a movie. So in our judicial system, each and everything is going very linear. If we are just try to retrieve one example, we are just a few days earlier, I heard an order that after 22 years, one person can get the justice. 22 years, after 22 years. This is his good luck. It might be possible that he is not available to receive that order. So whenever we have this kind of dispute, we can take the alternate route, that is known as arbitration. If you and me is going for contract, we will make some person, make Paul sir as an arbitrator, that okay, if there is any dispute between you and me, Paul sir will be there, and what Paul sir will do? He will work as arbitrator, and whatsoever he will say, you and me is bonded, and we have to follow that order. So what is the procedure for that one? First of all, under this contract, we have to mention an arbitration clause, and that clause must be written, and that clause must be registered. So we will write that if there will be any dispute, Mr. Paul will be the arbitrator. What will happen next? If there is any dispute, we move to Paul sir. Third step, what will Paul sir will do? Paul sir will do a date that you both have to come to me and you have to give your evidence. Next step, we will go to the Paul sir, we will put our evidence, and then Paul sir will try to see those all evidence and conclude, and he may pass the order. Whatsoever being ordered by the arbitrator is known as award, and that award shall be effective on you and me both. We are free to appoint the arbitrator, but once we have decided that this will be dealt in arbitrator, and once we have decided the arbitrator, now nobody A and B cannot deny to accept that order. You can challenge this order, but you cannot deny from that order. This is the procedure. Now, any more question? Yes, arbitrator done, this done, characteristics, difference between competition, this all done. Now the only thing is FEMA. Intentionally, I am eliminating this FEMA. We can take more question. Doctrine of Cyprus, what is the sustainable question relating to environment? What is the piracy of design, service and efficiency services, difference between MRTP Act and Consumer Protection Act, difference between capital account, current account? Check. First of all, we will start with this question. I will take all of your questions, so just keep asking me. I will try to answer that one. Now, what is piracy of design? As I mentioned at the very beginning of this webcast, that under IPR we have to deal 5 acts. One was patent, copyright, trademark, design, geographical indication. 5 things. So if we made some kind of design and somebody is copying that design, and if somebody is trying to make the product with same design, this is known as piracy of design. Now, trademark and design, there is small difference. What exactly is trademark and what exactly is design? First try to understand that one. If you are getting any kind of this stick, you can imagine this is a product of Nike. If you are getting, I don't think whether you will laugh or not, but I will try to, no, not successful. I was trying to make a panther, but I think this is like a rat, even not that one. Anyway, but if you are seeing a panther jumping over there, so how you are recognizing that panther? This is like Puma. Nothing has been mentioned about PUMA, but if you are seeing that panther, you recognize it as a panther. If you are getting the symbol of ICSI, this is our trademark. This is our trademark for the institute. So trademark is a thing which can reflect the business. This is in 2 dimensions, maybe in 3 dimensions, but design is what? This is the trademark of Mercedes. Kindly forgive me if I am not making very good design, or I am not making very good logo. I am not a very good artist, but I can clear your doubt. This is the symbol of Mercedes. You are getting some kind of logo on Mercedes. You are getting, I can just draw the trademark of Audi, because that is very easy. You have to do nothing. You have to make 4 things, isn't it? That 4 or 5? 4. So this is of Audi. But a Maruti company cannot use this logo, or Hyundai cannot use this logo. But what will happen if Maruti will keep their logo but make exactly same car which was made by Mercedes, which was made by Audi? That means trademark has not been copied, but design has been copied. This is the design of Renault's marker, and this is the trademark of Renault's. This is the difference. This written manner of Renault's is trademark, but the design, this shape and this structure is of Renault's. Unfortunately, I have only of Renault's, otherwise I can make the compare of both one. Another one. But if you go through with the laser, you will find that is some kind of heavy design. That means some more thickness and some more point and some other kind of things. So this is the design. So piracy of design means what? If the person who is not authorized, the person who has not taken the approval from the author of design is producing the same thing, this is known as piracy of design. Like the same man, there was one thing, and Wonder car, Tarzan the Wonder car, that is also example of piracy. That means that was made by another person, but someone another is trying to make the claim that this is made by me, and at last what happened? The Tarzan was taken the revenge from all those people. Anyway, that was the movie, but that was the piracy of design. Now, difference between MRTP Act and Consumer Protection Act. There are 3 acts to protect the consumer. 3 acts. What is that one? It's MRTP 1969, Consumer Protection Act 1986, and Competition Act 2002. These all 3 acts are to protect the consumer. How to protect the consumer? Suppose I am finding something, and what I am finding, I have purchased a fan, since it is a summer, so take the example of fan, and what I am finding that this fan is moving, and like a very obedient servant, that fan is asking to me, can I take a rotation? Can I take a rotation? And what was the ad? The fan which will remove all the heats, and the fan we will come with thunder. My God, this is thunder, this will thunder. He is just trying to ask me, should I take one rotation? This is defect. I am finding something and which is not fulfilling my demand comes under defect. For product, I am getting some kind of services, and that services is not up to the expectation, that is deficiency. So earlier there was one act, MRTP Act, and MRTP Act was emphasized on precautionary measures. That means if something is defective, if some services had deficiency, it shall not be made to the consumer. That means these things shall not be allowed to come to the market. That means preventary measures. That means we have to be careful so that we shall not meet to accident. But consumer protection is what? Consumer Protection Act is especially meant for a different thing. It has been meant if we are getting some kind of accident, there must be some hospital where we can get the treatment. This is very good that people should follow the traffic light. But if someone is overshooting the red signal, and if someone is getting hurted, then there must be hospital. So when we started with the MRTP Act and we come to the Consumer Protection Act, our need was fulfilling. By the combination of these 2 acts, we were able to meet our demand. MRTP prevention and Consumer Protection Act much more emphasis on the relief and the compensation. But 1969, you can imagine that time, 1969 and 2002. As the time passes, the business has changed drastically. Earlier, there was no foreign collaboration. Now there is foreign collaboration. Earlier, only in India we are getting the product. Nowadays, even we are using the marker, this is of Renault's, a company situated outside India. We are using camera, we are using mobile phones. This is not from the Indian company. These all are from the company situated outside India. So now what we have to make a control over those company also. But under MRTP Act, that was not possible. Under MRTP Act, there was provision that if someone is dominant in the market, that is bad. That means if the company had very good accessibility in the market and they have very dominant market, that means if all market has been captured by one, that was not appreciated under MRTP Act, but not. Competition Act is saying that dominance is not bad, but abuse of dominance is bad. If some company is very big, that is not bad. But if that company is making some kind of activity due to having very much control over the market, then that is bad. So under MRTP Act, number of things which has not been covered, like foreign cartel. If a company situated outside India is making hands with Indian company and then doing business, that was not directly controlled by MRTP. That is controlled by Competition Act. So we find the need and we felt urgent necessity to remove this and replace some another act in place of MRTP Act, and we introduce Competition Act. Obviously, here the regulatory body is Competition Commission of India, and in MRTP Act, the regulatory body was what? The regulatory body was Director General of Investigation and Registration. Fine. Now, service and confiscation of essential commodities, seizure and confiscation of essential commodities. Okay, fine. Now, there is two words. One is seizure and another one is confiscation. Just try to understand that one. Suppose this marker is not of mine. What I am finding that Reynolds company or a person is making a very good storage of this Reynolds marker. Just forget about this marker. Just take the example of onion. What I am finding that is stockist Mr. X is trying to make a very good accumulation of 5 ton onions, and he has the license capacity of only 1 ton. Then the regulatory body will go there and regulatory body will take control of those all 5 tons. This is called seizure. Taking anything against the will of another person. This is called seizure. But what will happen? If that thing has been seized by the regulatory body, the market price of onion is not going to be reduced unless that onion shall be bring to the market for the use of consumer. Then only the price will reduce. So what the government is doing? Then he is distributing it through the distribution channel. This is known as confiscation. So this is the seizure and this is the confiscation. But when the confiscation has been made, it shall be bring to the district magistrate, so that district magistrate can verify that this much of amount has been seized and this is the quality which is being seized, and it shall be confiscated among the different person. Fine. A difference between capital account transaction and current account transaction. That means I should take immediately the FEMA, not an issue. I am writing this thing, and after 2 questions I will answer FEMA, because I will try to explain FEMA in my own style so that you can get most out of it. I am writing it. This is capital account transaction and current account transaction. And earlier question was short introduction was FEMA. That is not a question. I will cover that one. So difference between MRTP Act and Consumer Protection Act, I will make you a clear picture of MRTP Act, Consumer Protection Act and Competition Act, so that if they are asking you about MRTP Act and Consumer Protection Act, you have to mention about MRTP and Consumer Protection Act. If they are asking you MRTP Act and Competition Act, you can match that one. Service and deficiency service. Now, service has been defined that if a potential user is capable of getting any kind of legal services, that is comes under services. That means potential user means what? I am a company secretary. I am providing my consultancy. But if I am charging 1 lakh rupees for the incorporation of company and you are able to give me 1 lakh rupees, then you are potential user. But if you have only 20,000 rupees, then you are not potential user. And for you, I am not a service provider. So if you are getting an account with your bank, then you are getting the services. If you are hiring a taxi, you are getting the services. So service means all kind of services which a potential user are getting. Importantly, banking, financial institutions, like any tuition, any kind of classes, those all comes under the services, hiring of taxis and those all things. But what is deficiency in service? If someone is committing that services, that this is of a particular standard, and if he or she is not fulfilling that one, this is comes under deficiency of service. But one important thing, you cannot claim any kind of compensation until unless you are able to prove that there is negligency. Then only you can make a monetary compensation. Like you went to a doctor for the treatment. I cannot take you in this example. Let's consider about myself. I'm going to a doctor and I'm suffering from cough and cold. I'm going for the treatment of cough and cold. That was very talented doctor. He given me one injection, and after that, now I'm suffering from typhoid. I'm suffering from kala-jar. So what do you feel? What do you feel? If that doctor is able to heal me, that is not deficiency in service. But he given me one injection and now I'm suffering from severe disease. This is deficiency in service. But I cannot take any kind of compensation until unless I am proving two things. That I paid some amount for that services. That shall not be free of cost. If I am going to a government hospital, and in government hospital I am getting that kind of things, then I cannot claim any kind of compensation. And that's the reason number of people are being killed, or number of people is suffering from various kind of disease, and those people are not treated well in government hospital, but they cannot go under Consumer Protection Act. They can go to the court. But if you are going to Max, if you are going to Apollo, if you are going to Scott Hospital, then you are paying the money, and if you are paying the money, you can take the compensation. But for taking compensation, another thing is that there must be negligency. And negligency means what? You are finding that doctors are doing operation in movies, of course, and how they are coming? They are coming with a shadow face. Sorry. So what do you mean by this sorry? This means what? I was not able to survive the patient. So what you will do? You will make a compensation claim only when there is some kind of negligency. Sometimes you are finding that there is one knife which is remaining after the gallbladder's operation. Doctor is finding what? So I am taking a gallbladder from that stomach, so why not I put some kind of my big or my spoon or my any kind of knife over that. If that kind of activity is there, this is deficiency in services. Deficiency in service means all the reasonable care shall be made by the doctor. Doctor is making the injection and that injection is expired. My God, doctor is a literate one. He should see that whether this is expired or the expiry date is still remaining. Then only he can inject. So under deficiency in service, you have to prove two things. You paid for the services and there was negligency from the side of service provider. Fine. Now, piracy of design done, this done, seizure and what substantial question relating to environment. Now, there is one word, and that word is sustainable development. Sustainable development. Kindly understand this one. What exactly mean? Our earth has some kind of limitation. It is very true that due to civilization, we need more space to live. We need more offices to employ people. We need more spaces for our different work. But if we will cut the forest and if we will destroy each and every kind of things, then this environment shall not be available for the next generation. So sustainable development means what? Sustainable development means you have to avail the facility of environment, but keeping in mind that next generation can use it. That is called sustainable development. That means development can sustain. In similar fashion, suppose a person is getting 90% marks in class 1 and still he is maintaining this in class 2. This is called sustainable. But unfortunately or fortunately, he get a chance and score 90% in class 1, in 92%, in class 2, 30%. This is not sustainable development. So our law is saying Doctrine means always means explanation. So the explanation coming from this word is that whenever we are using any kind of luxurious thing, it is very true that environment get polluted. This is very true. Industrialization will pollute the environment, but we have to make the environment up to a limit where the other person can utilize it, and we should not exceed that one. And through that one, you can understand the concept of carbon credit, because nowadays each and every countries had made some kind of limitation that India shall not emit more than that one, pollution or in the environment. So this all has been done. Any more questions, sir? Kindly pass on. What is mean by mens rea? Mens rea means guilty intention. That means if someone is doing something but not with mens rea, that means not with guilty intention. What exactly that one? Suppose you are coming from one side, I'm coming from another side in a bridge, and we both get struck, and I fall down and I died. There will be no criminal cases against you, because it was not done intentionally. So mens rea means what? Mens rea means with guilty intention. That means you are doing something with guilty intention, and this word is being used in essential commodity. If you are storing essential commodity and there is no guilty intention, why there is no guilty intention? Suppose there is marriage of my sister, I stored onions beyond a family's capacity, I stored tomato, I stored number of vegetables and number of another things, because I have to give the party to 1,000 person, and suddenly there is raid at my house, and they are coming and asking me that give me the permit of storing this much of onion, this much of potato, this much of tomato, and this much of this and that. I said I don't have the license, but they cannot make any kind of seizure and they cannot arrest me. Reason what? There is no mens rea. Because mens rea means guilty intention. If I am storing that one to sell it when the price will increase, then this is called mens rea. And if I am using it with a fair mind, this is not mens rea. So mens rea means guilty intention, and you have to explain it and you have to correlate it as per essential commodity. What is constructive trust? There are various kind of trust under Trust Act, like public trust, private trust. Constructive trust means what? The trust which has been created by the order of court. That means, suppose I have 3 flats and I am appointing Pal sir. Sir, you are trustee and you have to take care of this property, and whatsoever you are getting from this property, kindly utilize it for my daughter's education. Then Pal sir become what? Then Pal sir become trustee, and my daughter become beneficiary. But what exactly happening? Suppose I died suddenly. I was not able to appoint Pal sir as my trustee. I died in a road accident, me and my missus, and I was not able to create a trust. Then court will order to my nearest relative or any another person that you will be trustee of the property of Mr. Pankaj Kumar, and you will take care of that property and you will be remunerated for that one, and all the benefit coming out of that shall be given to his daughter, her daughter. So this is called constructive trust, which trust has been created by the order of court, not by the author, because author is not available. Clear? Now, difference between coercion and undue influence. Okay. Under Contract Act. Contract, there are some essential elements of contract. What are those essential elements of that contract? If you are making any kind of contract, then the object must be legal, the consideration must be legal, and there must be free consent and genuine consent. That means the consent must be given without any force. Now, if I am making any kind of contract and I am just trying to make some kind of influence, that you have to sign over here, otherwise I will sign somewhere. Are you getting me? This is called undue this is called coercion. That means I am making that person and I am forcing that person to sign the contract under what? Under pressure. But if I am only threatening but he is not signing, this is not coercion. Coercion means when a person is signing under some pressure, this is known as coercion. But what is undue influence? Undue influence is little bit different. What is undue influence? Suppose I am your teacher, and I am teacher of A and B both. A and B both are my student, and P is teacher, Pankaj is teacher. A is trying to buy something from B, and I am convincing B. Since I am a teacher, then B get influence of me. Okay, sir is saying something, so I should make a contract with A. Then this is called undue influence. So undue influence and pressure is some different thing. But if we will try to correlate it with coercion, then what happened? A is trying to buy something, then he is sending Suleiman Bhai. You are getting Suleiman Bhai, a gunman, to B, and saying that just sign over here, otherwise all the 6 bullets will be in your mind free of cost. Then what happened? B is signing over there. This phenomena is known as coercion. But B is saying that what? I'm not afraid. Do whatever you want. And he is not signing. Then this is not coercion. If somebody is signing under pressure, under the influence of any this kind of person, illegal activity, this is known as coercion. And this is very important. Now, next question is resale price maintenance. Resale price maintenance, I will correlate this resale price maintenance with another thing also, because sometimes you have to understand this. Resale price maintenance and collective price, or resale price maintenance and collective price. Now, first I discuss collective price. I already given one example. Reynolds, Lexer and Camlin. These 3 companies were made one kind of association, and they decided that they will sell their market at a price at 25 rupees. This is called collective price maintenance. What is known? Collective price maintenance. So collective price maintenance is being made between sellers, because Reynolds is seller, Camlin is seller, and Lexer is seller. They all joined their hand and decided to sell something at 25 rupees. This is called collective price maintenance. Now, what is resale price maintenance? As the word resale means what? Again, I have to sell it. This is always between buyer and seller. Just mind it. Collective price fixation is between sellers only, but resale price maintenance is between buyers and sellers. I am giving you an example. Reynolds company is producing the marker, and Reynolds company is selling it to the distributor. To whom? Distributor. And telling that distributor that, well, Mr. Distributor, you are not supposed to sell it beyond 20 rupees. This is called resale price maintenance. Now, what this distributor will do? Now the distributor has to pass it to the retailers, but he cannot sell it beyond less than 22. Less than 22. That means he is controlling the price. What Reynolds company should say? Reynolds company can make an MRP, maximum retail price, that the maximum price is 20, but you can sell it whatever you want, because you have your own profit margin. If you want to reduce the profit margin due to competition, you can do it. Until unless you are giving such kind of opportunity to your buyer that they may sell it any price beyond a price fixed by it, this is known as resale price maintenance. MRP is not resale price maintenance, because MRP is what? Maximum retail price. So this retail price maintenance is between buyer and seller. Reynolds company is selling it to the distributor with a condition that they cannot sell it less than 20. This is resale price maintenance. They may say that you can sell it maximum at 20. If he is saying that, then this is not resale price maintenance. Fine? Okay. What is doctrine of feeding and grant by Stoppel? Now, whenever you are finding the word doctrine, so don't get your mind stuck. because what I am finding from most of the students, whenever they are getting this word doctrine or doctrine, you can pronounce it anyway, they are finding that this is something very, 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 very crucial. So doctrine is an explanation. Feeding the grant by estoppel. This is an order. This is an order. The order is given only when I am correlating it to the Essential Commodities Act. Suppose there is a raid at my house, at my shop, and I have a capacity of storing how much? 5 ton. But at that moment I was not there. There was one servant over there. He is not very literate. The inspector is finding 4 ton tomato over there, and he is going to seize those all and saying that show me the certificate that you have a capacity of storing this much. He cannot produce that one, and that has been seized. After some time I am coming with all those proof, but what happened, since this was tomato, and if that was carried for more than 2 or 3 days, then automatically it will become ketchup. So it was already been confiscated and distributed in the market. Now I will come with the estoppel order, that okay, since you have done it, that was wrong because I have that certificate. This is the estoppel order which can overshoot the order of the earlier person, that now you are not supposed to do that thing and you have to return my thing. In that case, the government, that means the authority who has seized that product, cannot return those tomatoes because that has been taken by a lot of people in matar paneer and other dishes. So how they will compensate? They will return the money with interest. Clear it? Now, explain negotiable act or instrument. Achha, that means instrument. Now, negotiable act is nothing, negotiable instrument is over there. Negotiable instrument means what? The instrument which can be transferred to another person is known as negotiable. Normally, what we are finding from the negotiation, that this is a conversation between 2 people. But in law, negotiation means a thing which can be transferred. Like if you are transferring something like promissory notes, bill of exchange, if we are able to transfer it to any other person, this all comes under negotiable instrument. What is the mode of revocation of an offer? Under Contract Act, first of all, for being a contract, there must be offer, then acceptance, plus consideration, then enforceable by law. If you are finding these all things, then this is a contract. Now, the first thing is offer. Offer must be given. Suppose I am giving an offer, and I am giving an offer to Pal sir, that sir, come and buy this marker at rupees 100 rupees, one marker. What Pal sir is finding that, sir, are you thinking I am mad? Why I will purchase it at 100 rupees? Can you give me at 80 rupees? Then now this offer has been revoked. If someone is answering my offer not in the same manner, then it has been revoked. So there are various methods through which our offer can be revoked. First of all, if he is not replying in the same manner, that means I am saying that if you are saying yes, kindly say it in writing, or mail me, or SMS me, or you can call me. If he is not doing so, the offer has been revoked. Second thing, I am giving offer at 100 rupees, I am finding another counter offer that give it me to 80 rupees. The offer can be revoked. Before the offer is being accepted, I died, or the person to whom I am offering is died, then the offer can be revoked. So these are the mode under which offer can be revoked. If the offer is revoked, then there is no question of contract, because first offer, then acceptance, then consideration, and then enforceable law, then only the contract. Now, what is the difference between day of acceptance and day of deemed acceptance? Now, what is acceptance? This is a part of MSME Act. Micro, small and medium enterprises. Just come here. Micro, Small and Medium Enterprises Development Act. Day of acceptance means what? Day of acceptance means, suppose I am manufacturer and somebody has demanded something to me. If I am sending it to the another person and the day on which he is getting the delivery is called day of acceptance. But what happens in this case? If he is not satisfied with my product, then he may raise the objection that, sir, this is not up to the mark for which I had made a contract, because this is a deteriorated quality. Then what I have to do? In that case, I have to take that product and again I will just try to remove all the defect from that product, and then I have to return it back. And these all things shall be done within 45 days. So day of acceptance for especially MSME is 45 days. That means if MSME, micro, small and medium enterprises, is sending anything to the person, then he must have to make the payment within 45 days. And if he is not making within 45 days, government shall make all reasonable steps to recover the money within next 45 days. And what is deemed day of acceptance? Deemed day of acceptance means if I remove the defect and still there is no conversation from their side, then the day I delivered that one after removal of that defect is considered as deemed day of acceptance. Otherwise, the day on which the product has been delivered to that fellow is known as day of acceptance, and deemed acceptance when the remedy has been made and nothing has been communicated to me. Anything else? No. Come again. What are the way of discharging a contract? Discharging a contract means what? Fulfilling of a contract. There are various ways in which the contract can be discharged or eliminated. That means the deal has been made that I will transfer 100 piece marker. I transferred it. I made the delivery. That means the contract has been discharged. The next one, before the delivery, we two people has agreed that there will be no contract. They are not looking for 100. I am not looking for supplying of 100. The contract will be discharged. The time mentioned over that this contract is valid for next 5 months, next 6 months, and the time has been done. So these are the way in which contract can be discharged. So discharging of contract means either it has been fulfilled or it has been modified by the will of both the parties. Geographical indication of goods with example. Okay. Geographical indication means what? Intellectual property right. Intellectual property right means something has been created by your intellect. In patent, you are inventing something which is unknown to the people. In copyright, you are writing, you are making movies, those all things, and that is definitely unknown to the people. Under trademark, you are creating some kind of logo, symbol, any kind of thing. That may be anything, like Thanda matlab Coca-Cola. This is also a trademark. A punchline can be a trademark. Aao kuch tufani karte hain. This is also a trademark. Dar ke aage jeet hai. This is also a trademark. These all are the trademark. In the similar manner, when the trademark is being used, this can be used only by one person. Thanda matlab Coca-Cola. This can be used only by the product of Coca-Cola. Thumbs up cannot say Thanda matlab thumbs up. Thumbs up will say aao kuch tufani karte hain. Now, in geographical indication, number of person can use that thing which is residing in that location, like Basmati rice, Kolhapuri chappal, Banarsi sari, Kanjivaram silk sari. So if any of the trader is producing that silk sari and that is related to that geographical region, they can say that this is Kanjivaram silk sari. Any trader who is producing saris at Varanasi, he can say that this is Varanasi sari, but it cannot make that any person who, the trader who is at Delhi, can say that this is Banarsi sari. No. There is some kind of climate, like Nagpuri orange. What do you think, that orange is only cultivated at Nagpur only? Not. There are number of places from where you can get the orange. But the climate and the weather of Nagpur is such that you can get a very good orange out of there. So if you are producing orange over there, then only you can say this is Nagpuri orange, yeah, Nagpur orange. This is the geographical indication. Geographical indication means what? This thing indicate to a particular area, a particular segment. Now, conciliation and mediation. there are three things. One is arbitration, another one is conciliation, and another one is mediation. These conciliation and mediation are very much similar. This arbitration and conciliation is very much similar. So what is the point of this similarity? In arbitration, whenever we are making any contract, we have to mention the arbitration clause. That means if we have mentioned the arbitration clause, then only we can go for alternate dispute resolution. But the conciliation is what? Any dispute has been arises and the arbitration was not made, then we can go for the conciliation. Mediation is the same thing, but in mediation, the person who has been appointed as mediator can be of your choice, can be of my choice, or can be of both choice. But whatsoever be the order made by the mediation is not an order. Mediation is only to mediate, and all the activities which has been done by the mediator can be validated only when the both parties are concerned. Like A and B has conflict. A and B both has conflict on any matter, and the mediator is trying to mediate A and B. Okay, you just suppose A has taken loan of 5 lakh rupees and B is the bank. What will happen here? Then mediator will try to tell the bank that you have to just charge 5 lakh rupees and just forget the interest. And A, they will say the A that okay, at least say 5 lakh, at least deposit the 5 lakh rupees and forget about the interest. But this cannot be challenged in court. But whatsoever be provided by the arbitrator can be challenged. That can be forced. That means if arbitrator is saying that B has to pay 5 lakh rupees plus 10% interest, then A has to pay that one. Otherwise, all the property of A shall be seized. But there is no such case in case of conciliation and mediation. The most important aspect is arbitration. The inferior is conciliation because there is no legal effectiveness, and the another less one is mediation. Conciliation can be made when the dispute can be arises. Mediation can be made any point of time. Any point of time. Suppose you are under litigation, and now you are finding no scope of end of this litigation because you are finding each and every tariq, another tariq. So what you are doing? You are coming in front, that means you are making outside court settlement and there is one person. But this will come effect only when both people are agreed. So arbitration has legal effect, conciliation has no legal effect, mediation has no legal effect. Government has made number of mediation center right now, and mediation center and the conciliation can work for various aspects. This is for labor law, this is for employee and employer relation, this is for family thing, this is for another commercial aspect also. Fine. Now, what do you mean by share swap and pledge of shares under FEMA? Okay, so FEMA, there was some question. Current account transaction, capital account transaction, and now another one is pledge of share. 3 questions. Fine. Fast track procedure in arbitration. Mentioned in arbitration clause. Difference between trust and society. There are 3 ways through which you can do the welfare work. One is Section 8 company under Companies Act 2013, earlier Section 25 company under Companies Act 1956. Another one is society under Society Registration Act, and another one is trust under Indian Trust Act. This doesn't mean that you cannot do welfare work without the help of these 3 acts. You may do that, but you will get legal status only and only when you are making yourself in any of these 3 platforms. But for ECL point of view, you have to eliminate this one because this is the part of company law. You are discussing it company law. Now, you have to go through with society and trust. Society is a platform where common people are come together. They are not coming together for profit. They have some common need and they try to fulfill their common need, and they try to fulfill their common need under the eyes of law. That means they are a legal body under the eyes of law. You may have heard the name of Ekta Welfare Society, this welfare society. That means where 10, 30, 20, 50 families are residing, they appointed one security guard. They appointed one person to operate the lift. They appointed some mechanics to check their electric equipment. And what they are doing? They are not taking any benefit from that people. Each and every member are contributing. And there is law under Society Act that how many people can register the society. There must be bylaws of society under Society Registration Act. If the society is going to be dissolved, then the fund of society cannot be distributed among the member. It can be utilized with another society. And there is rule given that if society is trying to amend their rules regulation, that who will be the member, how the member can be eliminated, how the members can be inserted, those all things covered under Society Registration Act. But under trust, there are 5 things. First, one person shall be an author. Another must be a trustee. There must be some property. There must be beneficiary, and there must be an element. Element means a documents. After fulfilling those 5 criteria, you can create a trust. Now the trust may be for the welfare work. If this is a public trust, then this may be for all the people. In the similar fashion, like in society, this is a society for 20 family, for 30 family. In trust, similarly, if you have made the trust for 5 people, then this is for 5 people. This is for all the person, like charitable hospital. This is meant for all. Religious trust, that means mandir, masjid, those all things. So this is the basic difference, that trust shall be governed by those 5 elements, and it shall be governed by the Indian Trust Act. Society must contain some aspect like number of members in society, dissolution matter, clause shall be inserted under rules, and it must be governed by Society Registration Act. No person can utilize any amount of society for their own name, because society is a legal person and it can sue, and it can be sued by his own name, can possess the property and those all things. But in case of trust, all the property and all the things of author belongs to trustee. Trustee has some duty and obligations. Now, doctrine of election. Again, doctrine means principle. Doctrine means explanation. So explanation of election. What exactly is this one? Now, election means selection of something. Selection of something. Suppose I am providing you some benefit, and also I am putting some kind of obligation. So if you are trying to get that benefit, you must have to select that obligation also. Suppose I am appointing Pal sir as trustee and saying that, sir, please take these 5 houses, 1, 2, 3, 4, 5 small houses, and I am giving these 3 houses to Pal sir. Sir, do whatever you want from these houses. You may rent it, you may get the benefit, or you can make the commercial use, those all things. Definitely Pal sir become very happy. But I am putting some kind of obligation also. Sir, if you are getting this benefit, you have to use these houses, and you have to use these houses for old age people, and you have to put old age people over here, and whatsoever with the benefit you are getting from any kind of here, you have to utilize that one for their feeding, for their medicine, and those all things. Now what Pal sir is reverting back to me, sir, just give me only these 3 houses and take these 2 houses with you. Why? Because there is some burden. Why? He will take care of those all things. So doctrine of election is what? Either Pal sir has to take both things, this benefit and this obligation, or he has to take all these things to me back, that okay sir, I am not taking anything. Either take all things or return it back to the author. So this is doctrine of election. Okay. Types of mortgage. There are various kind of mortgage. Mortgage means what? I am taking money, and as a securities, I am putting something which is immovable in nature. This is called mortgage. But if I am putting something in securities which is movable in nature, this is called pledge or hypothecation. So first of all, you have to understand pledge and mortgage, and then I will come back to your question directly. And another was pledge of, I am writing FEMA question at one place so that I can collect these all together, because this is the thing which must be dealt at one go. You can keep asking FEMA question, I will write and I will make a complete list. So your exact question was mortgage. So this is mortgage, this is pledge, and this is hypothecation. In all the cases, you are taking some kind of money from some people. The only difference is that as a security, that means if I won't be able to return the money with interest, you can take that thing. So pledge and hypothecation on movable property, and this is on immovable property. I am taking money and I am giving my laptop to someone that until unless I am paying your money back, take this in your possession. This is called pledge. But someone is relying on me and saying that, okay sir, don't worry, you just give me the paper of your laptop, and the day you will give me money with my interest, I will return it back. Then this is called hypothecation. But in our case, we have to come at mortgage. Mortgage is what? When I am putting security, but that security is what? That means the charge has been created on immovable property. I am giving my property, that means land, building, or any kind of things. So there are various kind of mortgages, and those mortgages, importantly, the one is simple mortgage. Simple mortgage means I have taken the loan and given the property. If I won't be able to return the loan, then they will get the order from the court and they will sell my property and take the money back. That means exact money, their interest, their principal amount, and whatsoever be the expense of selling that property. And if anything still with those people, then they will give it back to me. Suppose the property is of 50 lakh, but I have taken the loan of only 10 lakh and 1 lakh was interest. And he has already sell it out at 40 lakh rupees. He will take his 11 lakh rupees and give me my rest money. This is called simple mortgage. Then a special mortgage. In a special mortgage, what exactly I am creating? In a special mortgage, this is a mortgage in which I am not only mortgaging something, but I am also creating some kind of right. And under this special mortgage, you will find English mortgage, usufructuary mortgage, you will find English mortgage, usufructuary mortgage, and various other. We will discuss we'll cover these two one. In English mortgage, what we are doing, whenever we are taking any kind of mortgage property, in that case, whatsoever be recovered only from that property only. Suppose a company has taken loan, and if the company has taken loan and company has mortgaged their land and building, if company is not able to pay, then all those things shall be taken back and those things shall be sold and the money shall be recovered. But if this is an English mortgage and that property is not sufficient to fulfill the loan and interest, then director's property shall be attached over here, Under usufructuary mortgage, what will happen? Until unless I am not paying the interest, then that property shall be given to the person who is giving me loan. That means the borrower will transfer his property to the lender, and lender will do what? Lender will just create a rent over there or make any commercial use out of that and utilize that one until unless all the principal amount and interest has been recovered. This is usufructuary mortgage. So there are various kind of mortgage over there. Okay. So now this has been done. Anything more we have? Okay. What is abuse of dominant position? As we discussed, and this is of Competition Act. Competition Act, abuse of dominance. If you remember that we will discuss three topics: MRTP, Consumer Protection Act, and what? Competition Act. MRTP Act, if you are having control over the market, then this is dominant position. But abuse of dominance means what? You are trying to sell their product at higher cost. This is abuse of dominance. You are not providing those people the quality which shall be provided to those people, then this is abuse of dominance. You are making unreasonable terms and conditions for buying that thing. This is also known as abuse of dominant position. Transfer for benefit of urban person, unborn person. Transfer for benefit of unborn person. Okay. Now, in our Transfer of Property Act, it has been mentioned that property can be transferred, future thing can be transferred, but future things cannot transfer until unless that things cannot come into existence. If you are transferring something to the unborn person, this will take effect only and only when that person come into the existence. Suppose you have transferred something that the son or the daughter of Mr. Pankaj Kumar is liable to receive that property. There is no existence and there is no transfer at all. This transfer shall come only and only when the child of Pankaj Kumar come into the existence. What are few market produce scheme, DRA, DNPC, EPCG under FTP? As I mentioned you earlier, this is EPCG. EPCG scheme is a scheme under which if you are just trying to import something and which is of capital nature, that means capital nature. Capital nature means machine. You are importing plant machinery, but what you will do from this plant machinery? You will do this plant machinery for the benefit of export. You will importing 1 crore rupees plant machinery and you will utilize in producing the product which will export it. And under FTP, government has to do what? Government has to increase the export. Since government has to increase the export, so government is providing you that there is no need to pay import duty over here. That means you don't have to pay anything over here. Suppose if the rate is of 10% assumption, so how much you should pay here? 10 lakh rupees. But there is no need to pay it. But for that you have to make an export of 60 lakh rupees in next 6 years out of this in case of SSI. But if you are not that one, then 80 lakhs product in next 8 years. This is EPCG scheme. Now, product scheme, for market and product scheme. Now, there are two schemes. One is product oriented, one is market oriented. If we are finding that this marker has a very good market outside India, in that case we will focus on this product and we do number of things. And what we will do, the government will provide number of subsidy for using of this product, for the promotion of this product. But there is some market focus scheme. What this market focus scheme? If we have very good market at USA of different kind of product, we will eliminate the cost, we will eliminate those transportation cost from India to USA under this market scheme. Fine. Now, what is KYC guideline? KYC guideline, I mentioned you under Prevention of Money Laundering Act. Prevention of Money Laundering Act. two kind of initiative has been taken to prevent the money laundering. One was national, another was global. Under global, we did Financial Action Task Force, and under this one, KYC guideline. There are 4 elements of this KYC guideline. 4 elements. First one, customer acceptance policy. Then customer, this is acceptance, this is customer test policy. This is transaction of account, and this is control management. Somewhere you will find some different word for this, but what exactly this one? The KYC guideline first element is customer acceptance policy. That means when someone is coming to open the account, first he will say that what his name, what his father's name, his date of birth, what exactly he is doing. If he is a student, he has to tick the student. If he is a professional, mention that CS, CS whatsoever, and mention those all things, address, those all things. And what is next? Then we will verify. What we will verify? That whether the thing which has been mentioned by that fellow is correct. That means if I am saying I am Pankaj Kumar, I have to prove I am Pankaj Kumar. That means there must be some evidence. If I am saying that my date of birth is this, then I must have to produce some documents which is evidencing that my date of birth is this. If I am mentioning that I am residing at this place or that place, I have to mention that one. So this is called your test policy. That means whatsoever being said by you, you have to produce the documents for that one. Now, next one is your transaction account. Suppose there is one student. If there is one student and there is a transaction in that account, and suppose 10 lakh rupees transaction per month in a student account, and I will tell you the real story. When I was a student, I opened one account with the State Bank of India, and then I transferred it. When I was residing at Patna, I transferred it to Delhi when I become a company secretary, chartered accountant, and some other thing. Suddenly I get a call from the bank that, sir, kindly answer that there is one amount, that was a few amount, that one amount has been credited in your account. How you are getting that much of amount in your account? Then I need to mention that one, that I am a company secretary now and I am a chartered accountant and those all things now, because in my account the thing was mentioned that I was a student, and in a student account the transaction was lakh rupees, was a severe transaction. So they will monitor the transaction, that is monitor of account. And if I was not able to satisfy that I am a person who may transfer or may get this much of amount as per my profession, then this will be reported to RBI, and then RBI will make a control mechanism. So this is the 4 element of KYC guideline. In your prevention of money laundering chapter and this act, I already mentioned layering, I already mentioned at this thing. One more thing you have to take care about this Financial Action Task Force, that might be asked. Anyway, this has been done. Now, the Competition Act 2002, why I am not coming to your specific chapter, because since I am getting your number of questions, so I am trying to elaborate this thing so that you can get both benefit. You can get a relief that, oh, all the question has been done, and meanwhile, whenever I find something which is relevant to that chapter, I will put forward those all things, like I mentioned in prevention in money laundering. The Competition Act 2002 does not prohibit dominance, but the abuse of dominance position. What does it mean? As I mentioned earlier, but I will elaborate because again I am getting the same question. Dominance is not prohibited. Abuse of dominance. Suppose there is some person, I am not a very healthy one, but suppose there is some man who is a muscles man, these kind of muscles, dole sole, these kind of muscles. But if someone is having these kind of muscle, should government arrest that person? Why not? He may fight. My God, if he may fight, then I will arrest at that person at that moment. If someone is very healthy, if someone is very health conscious, making gym and taking a nutritious food, then it's always been good. Why we will get an apprehension that if someone is having good muscles, he will fight with each other? That was the case of MRTP. MRTP was saying that if some company has dominant position in market, definitely that is bad. But Competition Act is not saying that. Competition Act is saying that if that muscleman is breaking the nose and breaking the teeth of someone, then that is bad, and then we will control. That's the only difference. Fine. What is flaw in contract? Flaw means shortcoming. Flaw means shortcoming, lacuna, limitations. That means a contract must have some elements, and that elements is free consent, that means offer, acceptance, consideration, and legal object. Flaw means what? Just opposite of this one. If in any contract you are finding there is no free consent, that is the flaw. Illegal consideration, illegal object on which the contract has been made with a minor one, that is the flaw of contract. That means coercion, that means by the force or undue influence. These all are the flaw of contract. That means these are the drawback of contract and negative, I think, the contract. Now, difference between market access initiative and market development assistance. Now, this is not very important because this is the part of FTP 2009 and 14. So, I request kindly don't do that. But since you have asked me, I am going to elaborate it. Market access initiative and market development assistance. Just see here, market access initiative, and the another one is market development assistance. Market access and market development. Suppose India is selling marker to America. What? Marker to American market. But we don't have right to sell duster in America because government has made their that means diplomatic level agreement that Indian exporter can sell only marker to the America. But if after some time they are making some kind of diplomatic arrangement that now Indian duster producer can sell their duster to the USA, this is called development. Now, market access initiative. Earlier, we were selling this marker to USA. Now, we are also making our good relation with UK, and what we are doing? We are making a market that Indian marker exporter can export it now in UK also, Canada also, Japan also. This is called market access, where you earlier did not have access of that market, but now you can access that market. But market development is what? You already had access of that market, but not for that product. Clear? But that was especially in the case of FTP 9 and 14. Now, in case of 2015 and 2015 and 2020, the name has been changed. Okay. Doctrine of Hindi, explain. Somebody is asking that I have to answer this question in Hindi. Can I do that? Okay. So the question is what? Kindly see that one. देखिए जरा इसको. मैंने आपको समझाया था कि अगर हम कोई भी बेनिफिट लेते हैं तो उस केस में जो है हम किसी भी तरह के जो है अपने ऑब्लिगेशन को इग्नोर नहीं कर सकते हैं. हमें दोनों ही चीज को क्या करना पड़ेगा? एक साथ लेकर के चलना पड़ेगा. मैंने एग्जांपल भी दिया था कि अगर मान लीजिए कि मैंने किसी को कोई मकान दिया और कहा कि आप क्या करें, आप जो है इन तीनों मकान कमरे को आप लें और इससे जो भी आता है वो आप अपने पास रखें. लेकिन ये तभी संभव है जब आप इन दोनों मेरे मकान को जो है वो क्या करते हैं, ओल्ड एज पीपल के लिए रखते हैं और यहां उनके सुख सुविधा का ध्यान रखते हैं, तभी आपको मैं ये दूंगा. अब यहां यही कहा गया कि या तो मुझे क्या करना है, डॉक्ट्रिन ऑफ इलेक्शन ये कहता है कि या तो मुझे उन सबको क्या करना है, चुनना है, या मुझे क्या करना है, सारे ऑफर को रिजेक्ट कर देना है. तो या तो मैं ये मकान से आने वाले पैसे का इस्तेमाल करूं और यहां जो ऑब्लिगेशन है ओल्ड एज पीपल को लाऊं, उनके जो खर्चे हैं, उनको जो मेडिसिन का खर्च होगा उनका टेक केयर करूं, और या फिर बोलूं मुझे कुछ नहीं चाहिए, ना ये फोकट का चाहिए मुझे ये मकान 3 और उसके बेनिफिट, और ना मुझे वो जिम्मेदारी लेनी है. I think this should be clear enough. आइए, explain combination in Competition Commission Act. Now, combination means what? Combination means when any person, it may be a trader, it may be a seller, it may be a distributor, it may be any person. If that person is coming together and that person is making any kind of arrangement through which they will deal in market, that is known as combination. But combination has not been restricted, but combination has been regulated. That means if you are making any combination which has appreciable adverse effect in the market, then that combination is known as anti-competitive agreement, and that combination is not allowed. But if that combination is not making any appreciable adverse effect in the market, then that is acceptable. I would like to explain you appreciable adverse effect at this point of time. Appreciable adverse effect means very harmful effect. Very harmful effect. That means if due to that agreement you are trying to restrict the market, if due to that agreement people are not getting that thing at the price which we were getting at earlier, that means the price has been increased. Now you are putting unreasonable condition. Now people was not able to get that much of quantity which they were getting earlier. If you are making any kind of this thing, this all comes under appreciable adverse effect. You are not giving liberty to the people, that means the producer, to go for the research and development. Suppose there are Samsung, there are Sony, there are Nokia and various other company. If Nokia is coming with 4G telephone, if the Samsung is coming with 4G, now Nokia has already been taken over by the window, that means Microsoft. But suppose Nokia, Microsoft or Sony, if Sony is coming with 4G technology, Samsung will come. So why they are making this kind of research? Because they always try to go ahead with another people. But if there is only one market, there is only one market player, that means, and that one is only Sony, why he will go for any kind of research and development? Whatsoever being produced by the Sony, people has to take that one. Now if you get that advertisement 4G, I get it number of times. 4G ad of that girl is making the advertisement of 4G. Now 4G has been launched by Airtel. What do you think, that Vodafone is not launching that one? Vodafone is also launching that one. Reliance is compulsory launching that, means that is known as Reliance 4G, in which you compulsory has to change your CDMA number through the 4G. So they all are coming through that one. If you are not making any kind of liberty for that one, this comes under appreciable adverse effect. Suppose Samsung and Sony comes together and there is no market competition, then research and development will stop. This will comes under appreciable adverse effect. If you are doing any kind of this is called anti-competitive agreement, and this kind of combination is not allowed. But if you are merger, there is merger, amalgamation, and if that is not making any appreciable effect, that is acceptable. Okay, so what is reversion and remainder as per Transfer of Property Act? This is reversion and remainder. Reversion and remainder. There are three ways through which property can be transferred. I will also give you some brief of that chapter also over here. One is absolute, one is reversion, and one is remainder. Suppose I am transferring something, and I am transferring something to the people that you are sole owner of that one. Do whatever you want. I am transferring my one property to Palsar. Palsar will utilize that one. Palsar want to sell it, he can sell it out. If he want to rent it, he can rent it. He can do whatever he want. There is no restriction at all. And after Palsar, it will directly go to their legal hire. This is called absolute. Now, reversion. Reversion means what? Reversion means I am transferring this one, but what exactly? I am selling that, sir, after 5 years, you have to give my house back to me. Utilize this for 5 years till you are in Institute of Company Secretaries of India. Take my house, you may live here or you may rent it, whatever you want. But the moment you will transfer from this place, you have to empty it and it will come to me. This is called reversion. But what is remainder? Remainder means I am transferring something to Palsar and saying what? Sir, it will never come to me. But after you, it will transfer to Sarika ma'am. That means this will not come to me, but it will transfer to Sarika ma'am. the legal hire of Pulsar is not authorized to use that one, and nor mine legal hire will utilize that one. This is called as reminder. Reminder means what? The property is not coming to me, but the property shall not be transferred to the legal hire to whom I have transferred it. It will transfer to someone else. But in reversion, what will happen? My property will come back to me. In absolute, my property will not come back to me. It will not be transferred to anyone else. It will go directly to the legal hire to whom I am transferred it. Okay, fine. Different foreign exchange and foreign security. Current account transaction, capital account transaction, shares pledge, and this one is foreign exchange and foreign security. What is wagering agreement and contingent contract? Okay, wagering agreement is an agreement of bet. This is not allowed in India. Like, if you are making a bet on IPL that where RCB will win or Delhi Daredevil will win, and if RCB will win, that means Royal Challenger Bangalore, Virat Kohli did a tremendous knock yesterday. If you are seeing the match and those all things, that's a great century. So if you are making a bet that if Virat Kohli will make 100 runs, I will give you 1,000 rupees. If not, then you will give me 1,000 rupees. This agreement is wagering agreement. In India, this is not allowed. Contingent contract. Contingent contract is what? Contingent contract means a contract. The contract which can be made only when some other thing can be fulfilled. That means this is depending upon happening of something that is called contingent. Like, I am promising that I will give A 10 kg of apple if the boat will come, or if the transport will come from Kashmir to Delhi, because I have to receive the apple first, then only I can transfer it to the next people. This is called contingent contract. Difference between pledge and mortgage. If I think this has been asked later, I have already discussed it. Pledge means I am taking loan and I am putting security as my movable property, my laptop, my wristwatch, any kind of thing. This is called pledge. But if I am taking money, I am putting as a security, creating charge on immovable property. This is known as mortgage. Doctrine of ostensible owner. Again, doctrine means what? Principle and explanation of ostensible owner. Now, what is ostensible owner? Suppose I am owner of a property and I am given the right that Pulsar may sell it out. I have given this right to whom? I have given it right to Pulsar. Then Pulsar will be the ostensible owner. I am the real owner and Pulsar is authorized by the real owner, so he is ostensible owner. But if Pulsar is transferring something to other people, later I cannot create a dispute that it has not been transferred by me. Since it had been transferred by Pulsar, so I am not going to fulfill this contract. No, this is the right of ostensible owner. If he is the ostensible owner, he can do whatever he want as per the contract, as per the authority given by the real owner. Eligibility of FDI in resident entity under FEMA. That means again I am writing FDI concept under FEMA. What does two-way fungibility scheme means? Two-way fungibility scheme means in case of ADR, American Depository Receipt, the person who is getting the ADR can convert their ADR into the equity shares of Indian company as underlying asset. And if he is not trying to get, and if he is not if he is not willing to receive the dividend in rupees, again he may transfer it and he convert it into the ADR. This is called two-way fungibility. That means ADR is converted into equity share, and again equity share is being converted into ADR GDR. This is called two-way fungibility. But in case of IDR, this is not allowed. This question is being asked from CMSL student, I think, because this is completely but not an issue. I can answer that one, so I answered it. But this is the part of ADR GDR. Anyway, so now what is difference between extension of trust and revocation of trust. Now, whenever we are creating a trust, so trust can be eliminated, trust can be dissolved under some circumstances when the thing has been done or some fraud has been made. But it can be extinguished only when the two parties being willing, and it can be modified by the consent of both the party. That means the beneficiary and the trustee. What is the meaning of certification trademark? Certification trademark, as I mentioned you, the trademark can be used by the one person. That means if Mercedes has taken that trademark, then only Mercedes can use it. If the Audi has taken that trademark, it can use by the Audi itself. But certification trademark is used by number of person if that person is fulfilling that specific criteria. For example, you are finding these kind of thing in eatable product. I have only one marker, and that's why you have to imagine that this is green and another one is red. So just imagine this is green and this is red. Now this is a certification trademark. All the product which is a waste product can use this certification trademark of green. All the product which is containing non-waste item can use this as red. Not only that one, ISI mark. You can remember that at Gunvatta ki pehchan, ISI mark ka nishan. All the pipes, all the switches and all the things which is having that kind of property can use that kind of ISI mark. Now, what is difference industrial property and intellectual property? Now, industrial property and intellectual property is that property which is already been created by the intellectual mind, but which is always been being used in some kind of industrial activity. Like number of invention can be made, number of trademark has been taken, number of design has been made. But if that is in the use of commercial activity, that is known as industrial property. What is export and trading house? Now, under FTP, foreign trade policy, government has given a status that if you are making export of that much of amount, that means in last 2 years plus previous 2 years and this current year, if you are making this much of export outside India, then you will get single star export house, then 2-star export house, then 3-star export house, then 4-star export house, and then 5-star export house. This is the status category. Now you may think that why this status? This status holder will get number of benefit. Number of benefit means what? If they are getting forex, they don't have to surrender those forex and they don't have to convert it into rupees. They can take it directly in forex 100%. But for other people, 70% shall be retained, but 30% shall be 70% shall be converted, only 30% can be retained, and they also get some other benefits. Contract of service and contract for service. Okay, what is this contract for service and contract of service? And contract for service. To understand is very easily, you have to go through with the example. Contract of service means there is a relation of master and servant. What kind of relation? Master and servant. That means employee and employer. Employee and employer relation. Now, if there is contract of service, suppose you are a company secretary, you cleared your exam. Executive, professional, training, each and everything. Congratulations. Now, you are in job and you are appointed as company secretary at some company, in some company. If you are not fulfilling any aspect and there is notice from ROC and that notice is of 5 lakh rupees, your boss, managing director, cannot tell you that you have to pay that 5 lakh rupees. Otherwise, I will sue you under Consumer Protection Act because you are providing services. Since you are an employee, so you are working under the guidance of your employer. And Consumer Protection Act is not applicable in case of contract of service. But in case of contract for service, in my case, I am a practicing company secretary. And if I am providing any consultancy to my company or my client, and that client is getting some kind of notice, that company may sue me under Consumer Protection Act under deficiency in service. So here there is no master and service relation under contract for services, but in contract of services there is master and servant relation, employee and employer relation, and this is not under Consumer Protection Act. This is under Consumer Protection Act. Doctors, engineers, CA, CS, CMA, advocate, those all are in practice are under contract for services. Those all who are in employment somewhere under contract of service. Consumer Protection Act is applicable when you are in practice, not in service. So what do we need? Why do we need competition in market? Very easy question, but I will frame it for you. Why we will need competition in market? I mentioned you, if there is no competition, nobody is going to make any kind of research. They will charge unreasonable amount and you have to pay it. Suppose you need 4 onions, and onions is produced by me. I am a farmer, I am not a teacher, I am a farmer, and I am producing onion. I will not going to sell it out at 20 rupees. I will sell it out at 2 lakh rupees per kg, because there is no competition. So competition is very, very, very important for getting variety of product, for getting continuous improvement in product, and for getting the product at very reasonable price. What is anti-competitive agreement? I already mentioned it earlier. Anti-competitive agreement means any agreement through which you are producing any kind of appreciable adverse effect into the market, that is known as anti-competitive agreement, like exclusive dealing, tie-up sales, bargain sales. These all are anti-competitive agreement. What you have to check? You have to check it out that whether that agreement, that means if that agreement is making any kind of appreciable adverse effect. And how can you check the appreciable adverse effect? I mentioned you, if due to that agreement prices are going high, there is no support to the market, there is no research and development, people are not getting the benefit which they were getting earlier, these all are appreciable adverse effect. Okay, briefly explain FEMA again. So now, question has been exhausted. So now I should come to the FEMA, and this is the list you have asked me related to FEMA. So I am now explaining the FEMA. Now, what exactly is Foreign Exchange Management Act? Government need to forex, and if government need forex, there are 2 ways. First, if we have forex, we have to take it out, and we will not allow any person to utilize this forex. Second thing, to make some kind of things through which this forex can be generated. I am a company secretary, practicing company secretary. I have my foreign client, forex client. I am getting dollar, I am getting pound, and what I am doing that, if I am getting forex, if I am getting dollar, I am surrendering it, I am getting the rupees. But if I need to go outside India and government will not allow me that forex to utilize it, why I will get the forex, why I will earn the forex? So FEMA has been introduced with that intention that we will generate forex not by restricting but by managing the forex. And under that one, they have made 2 kind of people. All the person who are dealing in forex. Forex means what? Any currency other than Indian currency is known as foreign currency. There was one question also, that was foreign exchange and foreign securities. Foreign exchange means what? Foreign currency is known as foreign exchange. And under this foreign exchange, number of things. Any currency other than Indian currency, or any instrument denominated other than in Indian currency is known as foreign currency, like a check which is denominated in dollar. This is also foreign exchange. Any draft denominated in pound is also foreign currency. Now, foreign securities. Any instrument which has been issued by any company incorporated outside India is known as foreign securities, like share issued by Infosys is Indian securities, because Infosys is incorporated in India. Share issued by Tata, that means Tata's various companies like Tata Steel, Tata Consultancy Services, Tata Infrastructure, various kind of Tata Motors. But if it has been issued by Microsoft.in, then this is foreign securities. So the company incorporated outside India issuing shares, this is also foreign security, debenture also foreign securities, preferences shares also foreign securities. Any kind of instrument issued by foreign company, that means company incorporated outside India. So it has been done, fine. Now there are two kind of people, one is PRI and another one is PROI. That means person resident in India and person resident outside India. That means any company, any individual, any partnership firm, any society, any trust, any kind of association in India can be distributed among two. Either it is person resident in India or it is person resident outside India. But whenever they are trying to get the forex, this forex can be utilized only for two work, and that work is current account transaction or capital account transaction. Like I have to purchase a house outside India, and for that I need forex because I have to purchase a house in USA. For that I need forex, I have rupees only. Then what I have to do? I have to convert my rupees into dollar. This transaction is known as one kind of transaction. Now the transaction through which a PRI increasing or decreasing any kind of assets or liability outside India is known as capital account transaction, or PROI. That means PRI increasing, decreasing any assets or liability outside India. Like I am purchasing a house in USA. That means I am a PRI because I am residing in India. There is a definition of PRI. For PRI, an individual must reside at least 183 days. That means more than 182 days in India in previous year. And he resided here for what? For employment, for job, for business, or for uncertain period. And he shall not go outside India for any of these three things. And in financial year, he is not outside India for those purposes. Since I am in India, so I am PRI. So this is capital account transaction. If any PROI increasing, decreasing any assets or liability, same thing, any assets or liability increasing or decreasing, where? In India. It's very simple. In case of PROI in India, that means if a foreigner is trying to purchase a house in India, for that he is taking the forex, he is coming with the forex and getting the rupees. This is called as capital account transaction. And apart from that, 10 transaction has been given. A list of transaction under section 6 subsection 3 has been given. That is called current capital account transaction. Now any transaction other than capital account transaction is known as current account transaction. RBI has made rule for current account transaction and capital account transaction, and CG has made rule for current account transaction. Now securities pledging. If someone is trying to pledge the security, that means what? He is trying to raise the fund, and what next? He is trying to raise the fund by depositing his securities, and that security, if that security is the foreign securities, in that case he needs to take the permission of RBI. Then only he can take that loan. That means taking the loan is not requiring any kind of approval from RBI. But if that loan has been taken by a PRI from the PROI by creating a charge on any kind of movable property, and which movable property is foreign security, at that case, in that case you must need a prior approval of RBI. FDI. There are two words. One is FDI and another one is FII. FDI and FII. Now what is the difference? FDI is making a strategic investment. A strategic investment means what? FDI is also making investment in India and getting shares of Indian company. FII is also making investment in India and getting the shares of a company, but difference is in their intention. Whenever FDI is making investment, he is making business and he will get the return from the dividend. Suppose Reebok company is offering Bata that I will come with you and I will invest 50 crore rupees in you in forex. Bata is providing the shares of his company. At the end of the year, they are getting dividend, profit, and he is distributing the profit to that FDI. This is known as FDI. But FII is only in a mood that he will get some kind of benefit and some kind of good return by selling off the shares. Suppose Bata company is available in a stock exchange. You can buy the shares. FII is making investment in Bata company through a stock exchange. And what he is getting? If he is making investment in through a stock exchange at rupees 100, he is just praying to the God, oh God, kindly make it rise and make it at 110 rupees. The moment it is 110 rupees, what is happening? The moment it is 110 rupees, at that moment, he will sell it out. I am repeating the same. What happening in case of FII? In case of FII, FII is making investment in shares with an intention to sell it out when the price will increase. Making investment at 10 rupees through a stock exchange, and when the price will become 110, he will sell it out. He is not going to assist in the business. He will not make any kind of technology support, but FDI will make technology support. Reebok will provide you a good machine so that the good shoes can be made. So FDI is making business, FI is making portfolio investment. FDI is allowed, but for FDI, FEMA has made rule. There are some conditions, which conditions shall be satisfied by the FDI for automatic route. There are two routes, automatic route and non-automatic route. Automatic route means what? Automatic route means if FDI is trying to make investment, there is no need to take any permission from RBI, from Ministry of Finance, from Foreign Investment Promotion Board. But for that, FDI need to fulfill some condition. But if he is not fulfilling that condition, they have to go through the approval route, that is called non-automatic route. But if FII is trying to make investment in India, FII must register with Securities and Exchange Board of India. Not only that one FII shall not make investment in one company more than 10%, and all FII shall not make investment by more than 25%. For me, yani for India, what exactly meaning of this? Suppose Infosys company is here. In Infosys company, if any institution incorporated in USA is also FII, any institution incorporated in UK is also FII, any institution incorporated in Canada is also FII. So jointly they cannot make altogether more than 25% shares, cannot take more than 25% shares of Infosys or any Indian company. If they are trying to do, for that Infosys need to pass, or an Indian company need to pass a special resolution. And by that resolution, they can go up to the sectorial cap. Sectorial cap means what? Sectorial cap means we have 38 sectors. We have 38 sectors means 38 sector means 38 industries. In 38 industry, we have made the limit that, like infrastructure, we are very, very clever people. What government of India has made? They have allowed 100% FDI in infrastructure. That means you come in India, you make investment in bridge, you make investment in road, you make investment in various places. How will you take it in your head, and how you can take it out of the India? So come here, improve our infrastructure and get out of it and leave it. That's why 100% is allowed. But in defense sector, only 26%. So after a special resolution, they can go up to secretarial limit. So this is about FDI. There's a number of things, but in summary, we can describe that one. Sir, we have any other thing? Achha. We will discuss something about FCRA, isn't it? Now, FCRA, Foreign Contribution Regulation Act. FCRA, I mentioned two here, 2 year. One was 1976 and 2010. Don't get confused. If somewhere by mistake you are getting 1976, there is no change at all apart from a few. Sections has been interchanged. In your examination, this is applicable. But why I am saying you this thing? Because provision has almost same, only the section has been interchanged and few things has been made. Foreign Contribution Regulation Act is an act which is controlling the foreign contribution. What is a foreign contribution? If anyone is getting anything from foreign source, the value of which is increasing 25,000, or any rupees in currency, Indian currency or foreign currency or any foreign securities, that comes under foreign contribution. But it doesn't mean that I cannot take foreign contribution. I cannot accept any gift. I can accept a gift, but there are few people whom the prohibition has been made, like Judge of India cannot take any foreign contribution. Any political party cannot take any foreign contribution. The person who is nominated for election cannot take. Any MLA, MP cannot take any foreign contribution. Any government employee, government servant cannot take foreign contribution. That means IAS, IPS officer or any officer who is working at government at a very decisive position, they cannot take foreign contribution. Yes, there are indirect provision also. Like if I am taking foreign contribution, since I am not a government servant, since I am not MLA, MP, but if I am taking foreign amount, forex, and I am going to transfer it and utilize it for the campaigning of election, I am not allowed for that one. So there are some situations in which foreign contribution can be taken, but for that prior approval is required. There are prohibition, these are the prohibition category. But there are some situations where you cannot take foreign contribution. There are some situations where you can take foreign contribution, prior approval is required. There are some situations where you can take foreign contribution, only intimation is required. And in the similar manner, there is one concept of foreign hospitality. It doesn't mean that hospitalize someone at foreign country. Foreign hospitality means Atithi Satkar at abroad. That means if someone is residing outside India and he is calling me, he is sending me tickets, he is giving me all the privilege of staying at his house, giving me food, and he is providing me the medical facility over there if I am going to sick over there. This is called foreign hospitality. There are some situations in which some people are allowed to take this one, but prior approval is required. So I have taken all your questions. I tried to just brief all about the things. Now what you have to do, just be a peace of mind, with cool of mind, just try to read all the questions and then try to answer it. Kindly follow the instruction which you will get in the question paper. After reading the instruction, then try to start the question. If you are finding anything which is not directly clicking in your mind, just keep your calm and just try to collect some information indirectly which is associated with that one. Read that, write that one in a very neat manner so that you can get best after this. So wish you all the very best. That's all from my side. Thank you very much.
Thank you, sir. In spite of your busy schedule, you spare your valuable time and enlightened our student by clarifying their queries. Dear student, one important announcement for you. The next webcast is on Monday, that is 23rd May 2016, on the subject company law.